Good afternoon. I'm Alexis Hall, Acting Program Director for the Division of Examinations Technology Controls Program. Before we get started, I'm required to give the standard disclaimer on behalf of myself and today's event speakers that the views expressed today are provided in our official capacities, but do not necessarily reflect the views of the Commission, the Commissioners, or other members of the staff. I'd like to welcome you to our Compliance Outreach Program on Regulation SP. The Division of Examinations compliance outreach programs are designed to provide a forum to discuss compliance issues in a practical way, share experiences, and learn about effective compliance practices. For today's event, staff from the Divisions of Examinations, Investment Management, and Trading and Markets will cover the new Regulation SP compliance obligations, discuss what to expect when interacting with examiners on an exam, and answer any remaining compliance-related questions. We've received many questions in advance of today's webinar, and we've done our best to incorporate the answers to these questions into our prepared remarks. However, if there are still any areas that you would like additional clarification on, please send an email to complianceoutreach@sec.gov, and we'll do our best to answer your questions during the last 15 minutes of the webinar. I look forward to today's discussion and to continuing to move forward together to promote compliance. Please welcome Keith Cassidy, the Acting Director of the Division of Examinations, to officially kick off our event.
Thanks, Alexis, and good afternoon. I'm delighted to welcome you to our first outreach event aimed at assisting registrants in preparing for compliance with the Commission's recent enhancements to Regulation SP. The SEC has long prioritized safeguarding customer information and ensuring robust customer protection through strong compliance. One way the Division of Examinations promotes compliance is by engaging in extensive communication and outreach initiatives with the industry. Building on the success of the Division's outreach efforts, today marks the first in a series of 3 tailored outreach events designed to help promote readiness and assist firms in their preparedness to implement these new amendments to Regulation SP. Not only will these events discuss new Regulation SP, the amendments, but they will also cover basics about what to expect when interacting with an exam team during an examination where Regulation SP is in scope. Led by our talented staff in the Technology Controls Program, as well as wonderful colleagues in the Division of Trading and Markets and Investment Management, these outreach events are designed to assist registrants in preparing for their respective compliance dates. Since Regulation SP's adoption in 2000, advances in technology and communications have changed how individuals interact with financial institutions. Unfortunately, this also means that bad actors have potentially more opportunities to steal personal information and commit identity theft, among other potential harms. The recent amendments are designed so that customers will have notice of the covered institution's potential data breach and take steps to protect themselves if they choose. We want to recognize and thank all of you for joining our program today. Your attendance demonstrates your commitment to our shared goal of protecting investors in the face of rapidly evolving threat landscape. We have 2 panels that will cover the history of Regulation SP, discuss the new provisions added in 2024, and share our approach to how we are going to examine for compliance with Regulation SP going forward. I thank you for joining us today. Please join me in welcoming our first set of panelists and the moderator of our first panel, Joe Murphy.
Thank you, Keith, for the introduction, and I'd like to welcome everyone to the first panel of today's Compliance Outreach event on Regulation SP for large firms. The first panel will cover a brief history of Regulation SP and the new amendments to Regulation SP that the Commission adopted last year. Before we get started, just as a reminder that if you'd like to submit a question, please send an email to complianceoutreach@sec.gov. Also, we are recording today's event, and the video recording will be available on the SEC's website in the next week or so. Now, for brief introductions, I will be the moderator for the first panel. My name is Joe Murphy, and I am the Senior Regulatory Counsel in the Division of Examinations Technology Controls Program. And I'm joined today by 3 colleagues from the SEC's rulemaking divisions. Please welcome Emily Hellman, a special counsel in the Division of Trading and Markets, Michael Khalil, a senior counsel in the Division of Investment Management, and James Wintering, a special counsel in the Division of Trading and Markets. So Emily, we'll start with you. Could you please provide a brief history of Regulation SP?
First off, thanks for the introduction, Joe, and I would be happy to provide a history. I'll try to keep it relatively brief because I know much of our audience is looking forward to hearing more about the amendments. But as a refresher, Regulation SP is a set of privacy rules adopted pursuant to the Gramm-Leach-Bliley Act and the Fair and Accurate Credit Transaction Act of 2003 that govern the treatment of non-public personal information about consumers by certain financial institutions. Now, the original version of Reg SP, adopted in 2000, had a couple of requirements. It required that brokers, dealers, investment companies, and registered investment advisors adopt written policies and procedures to safeguard customer records and information, and this is commonly referred to as the Safeguards Rule. Next, it required proper disposal of consumer report information in a manner that protects against unauthorized access to or use of that information, and this provision is commonly referred to as the disposal rule, and it also applied to registered transfer agents. Last, Regulation SP implemented privacy policy notice and opt-out provisions, which Congress subsequently amended in the 2015 Fixing America's Surface Transportation Act, and if you're like me and like acronyms, that is the FAST Act. And one last thing to remember is, although we talk about Reg SP often in the context of cybersecurity nowadays, Regulation SP applies to both physical and digital records and information.
Great, thanks, Emily. Can you provide us with an overview of the 2024 amendments to Regulation SP?
Of course, and I will also try to keep this high level because I know we're going to get a little bit more into the nitty-gritty. But as many of you are also probably familiar, the Commission adopted the amendments, I believe it was in May 2024, and they became effective in August 2024. The two big dates to remember right now is the compliance dates for the new amendments are for larger entities, December 3rd, 2025, and for smaller entities, June 3rd, 2026. And the amendments made several changes. First, it requires brokers, dealers, investment companies, investment advisors registered with the Commission, funding portals, and transfer agents registered with the Commission or another appropriate regulatory agency to adopt written policies and procedures for incident response programs to address unauthorized access to or use of customer information. And one important component of this is it includes providing timely notification to individuals affected by an incident involving sensitive customer information with details about the incident and information to help affected individuals respond appropriately. The amendments also additionally expand and align the safeguards and disposal rules to cover both non-public personal information that a covered institution collects about its own customers, as well as non-public personal information it receives from another financial institution about customers of that financial institution. It requires covered institutions, other than funding portals who have their own separate obligations, to make and maintain written records documenting compliance with the requirements of the Safeguards Rule and the Disposal Rule. It conforms Regulation SP's annual privacy notice delivery provisions to the terms of an exception added by my favorite acronym over here, FAST Act, which provide that covered institutions are not required to deliver an annual privacy notice if certain conditions are met. And finally, the amendments extend both the safeguards and the disposal rule to transfer agents registered with the Commission or another appropriate regulatory agency.
Great, thanks, Emily. Now, Mike, could you discuss the purpose and overall requirements for the incident response programs?
Absolutely, thanks, Joe. And I guess I'll start with the point that Emily just mentioned. As part of their safeguarding requirements, covered institutions will now be required to develop, implement, and maintain written policies and procedures for an incident response program that is reasonably designed to detect, respond to, and recover from incidents of unauthorized access to or use of customer information. And I guess the thing I think is worth highlighting here for our audience is just to remember what or how customer information is defined under the rules. It's a broad term, which for most covered institutions, except transfer agents who have their own slightly different definition, means any record containing non-public personal information about a customer of a financial institution that's in the covered institution's possession or that's handled or maintained by the covered institution on its behalf. And so when you think about that and all the ways that that can reach out, you get a sense of what you should be thinking about here.
Great, thanks, Mike. What about the new customer notification requirement?
Sure. So as part of the incident response programs, covered institutions have a customer notification requirement pursuant to which they must notify each affected individual whose sensitive customer information was or is reasonably likely to have been accessed or used without authorization. And here, again, it's worth remembering that under the amendments, sensitive customer information is a subset of customer information. That means any component of customer information, either alone or in conjunction with other information, that could create a reasonably likely risk of substantial harm or inconvenience to an individual identified with that information if it were compromised. And the rules provide some specific examples of sensitive customer information. First, with regards to information that's uniquely identified with an individual, that's reasonably likely to be used as a means of authenticating that individual's identity. So these would be things like a social security number, a driver's license number, a biometric record, or a unique electronic identification number, address, or routing code. Then there's information that is identifying an individual or the individual's account that could be combined with other information that could be used to gain access to the customer's account. So, for example, the rules state that this includes customer information such as a username or account number in combination with, for example, a security code, a credit card expiration date, a partial social security number, a security question and answer, or the individual's date of birth, place of birth, or a mother's maiden name.
Okay, and how soon do covered institutions need to provide this notice?
Absolutely. Under the amendments, covered institutions must provide the notice as soon as practicable, and not later than 30 days after becoming aware that unauthorized access to or use of customer information has occurred or is reasonably likely to have occurred, except under certain limited circumstances.
Okay, and what are those limited circumstances where a covered institution can avoid sending a notice?
Okay. First, under the amendments, there's an opportunity for covered institutions to rebut what's essentially a notification presumption. Notice will not be required if a covered institution determines, after a reasonable investigation of the facts and circumstances, that sensitive customer information has not been and is not reasonably likely to be used in a manner that would result in substantial harm or inconvenience. So I'd like to make a couple points about that because that's sort of a mouthful. First, the determination would have to be done within the 30-day time frame to avoid the notification obligation. And to be clear, under the rules, that clock starts when a covered institution becomes aware that there has been, or it's reasonably likely there has been, an incident of unauthorized access to or use of customer information. Second, a covered institution cannot avoid its notification obligations just because an investigation's results are inconclusive. That is, under the rules, where a covered institution becomes aware that it's reasonably likely that there's been an incident of unauthorized access to or use of customer information, but the covered institution is unable to identify which specific individual's sensitive customer information has been accessed or used without authorization, the covered institution must provide notice to all individuals whose sensitive customer information resides in the customer information system that was subject to the breach. On the other hand, under the rules, if the covered institution reasonably determines that a specific individual's sensitive customer information that resides in that system was not accessed or used without authorization, the covered institution is not required to provide notice to that individual. Obviously, these require covered institutions to make a number of facts and circumstances determinations. These provisions are supposed to work together to avoid unnecessary notifications where it's clear that there is no harm, but to otherwise ensure that where there is a risk of substantial harm or inconvenience, customers have the information necessary to make their own determinations about what steps they might want to take to protect themselves.
Okay. And then are there other exceptions to the 30-day window?
Yes. Additionally, the amendments permit covered institutions to delay providing notice after the Commission receives a written request from the Attorney General of the United States that this notice poses a substantial risk either to national security or public safety. The Department of Justice will notify the covered institution that the communication to the Commission has been made, so that the covered institution may delay providing the notice.
Okay, and then are there requirements about what the notices must say?
Yes, and I would encourage everyone to take a look at the rules for the specific requirements. But broadly speaking, the notices must include details about the incident, about the breach data, and how the affected individuals can respond to the breach to protect themselves.
Okay, and Mike, last question. Anything else you want to mention about these incident response programs?
Yeah, I guess just reiterate the rule scope, because I think that might help clear up some questions that are out there. The definition of customer information includes not only customer information that you, as a covered institution, receive from your own customers, but it also extends to customer information of another financial institution's customers that's been provided to you. And they also continue to apply to customer information that's handled or maintained on behalf of a covered institution, such as instances where customer information is maintained at a covered institution service provider.
Okay, great. Thanks, Mike. And then, Jim, can you discuss the new requirements for the oversight of service providers?
Sure, thanks, Joe. So in addition to everything else that we've just discussed, the final amendments also require covered institutions, as part of their safeguards rule, policies, and procedures, to establish, maintain, and enforce written policies and procedures reasonably designed to require oversight of service providers, which includes, among other things, to ensure that service providers protect against unauthorized access to or use of customer information, and provide notification to the covered institution as soon as possible, but no later than 72 hours after becoming aware that a breach in security has occurred, resulting in unauthorized access to a customer information system maintained by the service provider, at which point covered institutions would have become aware and would need to initiate their incident response programs that Mike just discussed. Covered institutions are also empowered under the amended rules to enter into a written agreement with their service provider to have the service provider provide customer notifications where those are determined to be necessary. However, regardless of whether such an agreement is entered into or not, the covered institution maintains the ultimate responsibility to ensure that this customer notification has taken place.
Great, thanks, Jim. Well, so that concludes our first panel. I want to thank Emily, Mike, and Jim for spending your time with us today and sharing your insight and perspectives with us. We're going to break for 2 minutes to set up for the second panel, so please stand by. Thank you.
Welcome back, everyone. My name is Matthew Gutierrez, and I'm a branch chief in the Technology Controls Program in the Division of Examinations. I have the privilege of moderating our final panel discussion that will feature 3 experienced and knowledgeable SEC Division of Examinations staff. And our panel will cover perspectives on the examination lifecycle and the division's approach to SP moving forward, important topics like the expected maintenance and production of certain policies and procedures, books, and records, and we'll discuss some SEC risk alerts. Before we get started, I'd like to introduce our panelists. I'm pleased to introduce Sal Montemorano. Sal is a senior specialized examiner and a leading expert in cybersecurity here at the Commission. He has years of experience in information technology and cybersecurity. Welcome, Sal.
Thank you.
Next, I'm pleased to introduce Michael Good, an IT specialist examiner in the Technology Controls Program. Michael has years of experience here at the Commission and a background in IT audit. Welcome, Michael. Now, finally, I'm pleased to introduce Steve Hagenbo. Steve is an attorney advisor in the Technology Controls Program, and Steve has spent some years in private practice and has years of experience here at the Commission. Welcome, Steve. Great. Now, thanks to each of you for sharing your perspectives today, and we can get started with our first question. Sal, we'll kick off with you. Can you talk about the examination life cycle? What should registrants be aware of when they are being examined by the Division of Examinations?
Sure, Matt. Good afternoon, everyone. I hope everybody's doing well today. With regards to the Division of Examinations and examinations as a whole, we conduct examinations pursuant to the Commission's statutory authority. So our examinations work to determine if the registrant is performing their business operations in a manner commensurate with or compliance with federal securities laws. So with that in mind, how do we actually achieve this goal? How do we actually examine and determine this result? If you have not been examined by the SEC before, we will look at your policies and procedures. If you have, we'll look at them as well. Point is we're going to review your policies, review your procedures to determine if they are in alignment with compliance with federal securities laws, and of course that they facilitate the business operations of your organization. So once we have reviewed those policies and procedures, we'll follow up by validating those policies and procedures are not only written, but they're also followed and enforced within the organization. And that'll be achieved by performing testing, some sort of walkthroughs at times. So any number of ways to actually achieve validating that you're utilizing and following those policies and procedures. I'm going to step back at a little higher level and talk about how we determine the registrant population for the following year's examinations. So in TCP, and each of the groups within the Division of Exams may have a little bit of a nuanced difference in how they perform this process, but we have about a 7 to 8 month exam planning phase where we perform a review of risk profiles, of tips, complaints, and referrals, of kind of industry activities that are occurring to determine what the registrant population may be in the following year. So it's not explicitly prescriptive. It's going to depend on what's occurring in the world, in fintech, in the environment. Obviously, artificial intelligence has come into play, and that has impacted us as to what type of registrants and what type of services and solutions we're looking into. Beyond that, if we actually look at how do we focus a given examination itself, each examination is focused based on the business processes and business functions of a given registrant. So what services are you offering? What technologies are you leveraging? And I say technologies, we are in the technology controls program. So from that perspective, we're going to leverage the technology aspect a bit heavier than some of our other groups within the Division of Examinations. And of course, as we're focusing those exams, we're going to also leverage the SEC priorities. So on an annual basis, the SEC does issue its priorities, and that kind of guides us as to what we need to focus on. But be aware that every examination, every registrant is unique in its own way, and we tailor our exams in scope to those registrants' business and functions. So with that being said, obviously today we're focusing on Regulation SP and the updates. And as I said, Michael, Steve, Matt, and myself, we're all from the Technology Controls program. So when you hear us talk today, we're talking from a cybersecurity and IT operations review standpoint in support of the protection of client data. So, but that's really at a high level, Matt. So.
Great insight. Thanks, Sal. So next we'll turn to you, Michael. So when an entity is selected for examination, what can they expect? And what are some ways that exam teams and the registrant can make the process more efficient?
Yeah, well, Matt, I think there are a number of things that can be done. And really the process really starts with first announcing the examination. So what we're going to do is we're going to deliver an information request, which will have a list of documents that we'd like to see. And we'll usually send that to the regulatory contact, which is typically your chief compliance officer. We expect that records will be produced promptly. Typically, they should be available within 24 hours. However, there is typically a longer process, a longer period of time that we will allow in order for those records to be produced. Exam staff will then follow that up by reviewing that documentation. We may request additional documentation, have some questions, and then what we're going to do is then we're going to follow up either in person, by phone, or by video conference to make sure, again, sit down, talk to entity personnel, understand your operations, and then ask questions about the documentation that we've received. And then we'll follow that up again by with the documentation, we'll have an exit conference. And when we have an exit conference, we'll let you know about any issues we identify. And that'll also be the registrant's opportunity to ask us any questions. And then if there are deficiencies, we will follow that up with an with a deficiency letter. And there, what we'll do is we'll ask entities to respond in writing to any corrective actions they may take moving forward.
Thanks, Michael. And next, we'll turn back to you, Sal. So we've already heard about the types of areas being updated by the changes to Regulation SP. How will the Division of Examinations approach these areas during its exams?
Sure. Let me say up front that IT operations and cybersecurity examinations is not a new concept for the SEC. We've been performing these exams for 10 plus years, prior to even when I started in 2016 with the SEC. So many of the registrant population may be familiar with the cybersecurity initiatives that have occurred, I want to say from 2016 to 2020, over a number of registrants. That being said, we leverage that historical information to develop what we call subject areas, right? Subject areas that would cover over a dozen different, say, areas within IT operations and cybersecurity. And just to name a few, for example, networking would be a subject area for us. And within networking, we have what's called a work program, or a process that we utilize to actually dig deep into the different aspects of networking, such as looking at your network perimeter security controls, firewalls, intrusion detection systems. Looking at network segmentation, how do you break up your network to protect sensitive environments from say, a public environment where you may host a public website? So that's just one aspect. Another would be business continuity and disaster recovery as a subject area. So we would look into the capability to back up your environment, the resilience if you want to have a hot environment where if one environment goes down, you have another that can kick right on and continue business. So we would look into the BCPDR aspects. And then, of course, for today's topic, incident response. And I'll give a deep dive on incident response in a moment, but I wanted to just talk about the exam focus and the process a little bit further. So from an exam focus, as I mentioned in response to the first discussion, it's going to depend on the registrant's business and services, right? So depending upon the functions and services and clients the registrant is serving, that's going to help us focus in on our exam and focus the scope. Then, of course, it depends upon the network footprint, the network structure. Is the registrant, do they have a corporate office where all of the systems are on-premise, say, in their physical facility? Or more likely, are they in a hybrid environment where they're going to have on-premise systems and then systems in a cloud or hosted by a vendor or something to that effect? I don't want to distinguish between cloud and vendor. There are similarities there, obviously, but cloud is the new technology, right? That being said, once we understand the network footprint, we're going to want to understand how data is utilized. And obviously, in lieu of today's discussion, how client data is utilized. What this requires us to do is understand how client data is ingested, managed, and used within the network systems. I say organization, but it really in the systems. And then how it may be transferred out or stored by a vendor, interacted with by partners, clients, what have you. We want to understand all facets of how that data moves through the organization so that we can perform our proper assessment to understand what controls are in place to protect that client data. With that being said, I'm going to mention one of the quotes from Reg SP. The updates make any record containing non-public sensitive information that is in the registrant's possession or in its service providers subject to the registrant's incident response program. So if we listen to that statement, we think about what's the goal of that statement. And I think one of our colleagues mentioned this earlier. We want to make sure we have the capability, registrants have the capability to notify clients in the event that a breach reasonably may have impacted that client. So we in exams and in TCP, we're going to say, okay, how is the registrant going to be able to achieve that goal? Well, we're going to look at that incident response program from A to Z. We want to understand, do you have the policies and procedures updated to ensure that you can achieve the goal of identifying impacted client data? Are you enforcing those policies and procedures? What is your governance structure? What backup or support do you have from senior management to provide staffing and resources and tools to facilitate this incident response program? Is the incident response program going to be developed in-house? Is it going to be, as I said earlier, a hybrid where you may have vendors supporting the incident response? So we'll have to understand those aspects. But when we get down to the core of what we're looking at, it's going to be where's that client data? And we would hope to see a registrant's data mapping. And this may not be a standardized term, but I'll explain it a little bit. With data mapping, we want to know that the registrant has the capability to say, yes, our data resides here, here, and here's where our controls are. I'll give an example of what we've seen historically and what we're hoping to modify. Historically, we may have a registrant say, well, all of our client data, our sensitive client data resides in our CRM, our Customer Relations Management System. Great. We'll then follow up and say, okay, how does your representatives, how do they handle that data and use it in the course of business? Oh, well, they may download it locally, they may print it out, they may email this sensitive client data to the client or communicate with partners and such. So just in that short discussion, we've realized, well, your email system is going to host client data. Your endpoint devices may host client data. The CRM still does. But now we want to understand the controls on all of those components rather than just the single source of truth according to what the registrant provided us at that point. So hopefully that example illustrates what we're going to look at. But to really flesh out what we expect to see in an incident response program, I'm going to reference the NIST cybersecurity framework. And please don't get me wrong, this is not to say you must use NIST cybersecurity framework for your incident response program, but it is a good structure and a good guide to help us develop our work programs, and support our examinations. So within the NIST cybersecurity framework, it talks about the identification, the protection, the detection, response, and recover. So if we think about identification, we're talking about the capability to identify all assets, systems, applications, data within your organization so that you can then implement the protection, right? The security controls, the configuration controls that would limit access to those resources and systems. Once you've implemented those controls, we want to know that you have the capability to detect. And what does that mean? That means you have monitoring controls, right? So you may implement a SIM. And I'm giving these tools and technologies as examples, not prescriptive, just examples. But a SIM may aggregate all of your log data and allow you to alert on potential malicious activity. Without being able to look at your log data and without being able to alert and notify staff of a potential issue, you may not have the capability to actually respond to a malicious attack. And then, of course, we have respond and recover to control the environment, contain, and remediate the environment. So with that, we're kind of hitting end-to-end from a incident response program, and hopefully that covers the aspects that we're looking for.
Very helpful, Sal. Great. And another question for you. How will the division approach examining registrants' identification of risks?
Okay, great. Yeah. So if we think about identification of risk, we think about a risk management program, right? So we expect that the registrants will have assessed their risks in their environment. And if we think about risk management, I kind of break it up into three aspects. You want to identify your risks, you want to assess your risks, and then mitigate those risks. What we've seen historically is many organizations have a risk assessment program. They have a risk management program where they've actually done this risk assessment across their different lines of business. What we don't see is that they've considered the technical aspects or the cybersecurity aspects of their risks. They kind of say, well, this line of business has X, Y, and Z risks, but it doesn't talk about the supporting systems that may introduce additional risk. So what we're hoping is that the registrants will go a little bit deeper on their risk assessment and review the technology and cybersecurity controls that support their environments to identify risks to those platforms as well. So once the registrant has identified the risks, and if we go back to when I was talking about the client data and all the different repositories, obviously we're focusing on that critical client data or the sensitive client data and the risks that may impact those components or that data. So once the risks are identified, we would look for a assessment. And assessment can take many forms, but typically we'll see critical risks identified, high risk, moderate, low risks identified. And once they're rated, there's going to be an approach of how are we going to mitigate. With mitigation, we're talking about a number of avenues as well. You could either accept the risk, implement new controls to lower the risk or have more oversight on the risk so you actually reduce that risk, or you can avoid the risk. And so if I look at some of the requirements to ensure that vendors provide notification in reasonable times, you would expect that the risk assessment is going to include any critical vendors that may have access to sensitive MPI data and their capability to detect and respond to incidents of their own. And one risk may be that this vendor may not have a reasonable set of security controls in place, and you may try and work and ask them to enhance their security controls. That would be mitigation. If you felt they weren't going to address your concerns, that we would hope the registrant would move to a different vendor that might implement proper security controls, and thus you're avoiding the risk that you've identified. So once you've taken all of these steps of identification, assessment, and mitigation, we, of course, as we talked about going for policies and procedures, we're looking for artifacts to show that you've done this assessment, right? We want to see that you have some sort of risk matrix that lays out each of the identified risks so we can kind of see what scope you saw when looking at your own business. And then we can make a reasonable determination if we feel it's covered everything that should have been covered. And then, of course, the mitigating steps you've taken are reasonable as well. And then lastly, the reassessment. This should not be a singular effort where you perform a risk assessment and you've hit all aspects of the business and you're done. The environment that we're working in the financial industry, it changes daily, right? Technology changes daily. I mentioned AI earlier. Obviously, that's changed everything from a capability standpoint, from a security standpoint, as well as operations. And so we would hope to see a bit of an iterative process, whether you're adding a new line of business, you're adding a new tool, new capability, that gets incorporated into the risk assessment program. So an iterative review is always critical as well. And I think that touches on all aspects.
Great overview. Thank you, Sal. So we're going to turn to you, Michael, next. So one area that the updates to Regulation SP will impact will be the management oversight of third-party service providers. So what are some considerations covered institutions should know with regards to the division's approach for exams?
Yeah, Matt, well, I think there's a number of things. And I think first it starts with, it's important to note that while a registrant can outsource a function, it can't transfer that responsibility. So ultimately, the responsibility to protect customer information lies with the registrant. So as such, registrants should conduct due diligence activities to understand third-party service provider risk posture and conduct ongoing oversight to monitor service provider arrangements. Registrants covered by the Regulation SP updates are also required to create incident response plans, as we talked about earlier, to respond to instances of unauthorized access or the use of client information. So these plans must establish and enforce written policies and procedures that are reasonably designed to require oversight over their service providers. And so if a service provider has access to or stores customer information, registrants will need to conduct appropriate due diligence and ongoing monitoring of these service providers to ensure that they take appropriate measures to protect against and, depending on the circumstances, respond to breaches to client information. Updates to Regulation SP also create new obligations for registrants to notify customers. And a registrant's due diligence and monitoring efforts must now also take this into account, focusing on whether the service provider can adequately detect breaches and notify the registrant within the time frames of the regulation. And something else, registrants can consider entering into written agreements with service providers regarding expected activities. These agreements could even require the service provider to notify affected individuals on the registrant's behalf. And you should also consider working with your service provider to obtain assurances or certifications that your service provider has the mechanisms, policies, procedures in place to carry out these activities should they occur. And I think above all, you need to remember that, relying on representations alone may be insufficient. So if you have a reason to question these assurances, you may consider requiring your service provider to provide independent certifications or attestations.
Great, thanks, Michael. And I have a scenario for you to consider. So imagine you're a CCO and your firm experienced a weekend cybersecurity incident. You know the firm has some record-keeping obligations concerning the event. So what are some things that you would want to consider documenting?
Yeah, well, I think there are a number of things. So, firms should definitely listen up. And so first, what you want to do is you want to make sure that you document your policies and procedures that address your administrative, technical, and physical safeguards to protect customer information. So registrants ideally should maintain these policies and procedures with their policies and procedures addressing the disposal of customer information. And so when a firm detects an unauthorized access to or use of customer information, you'll want to make sure that you maintain written documentation evidence of these detections. You'll also make sure that you also want to maintain evidence of actions taken to respond and recover from these incidents. And you'll also want to maintain any records documenting notifications to affected individuals consistent with the requirements of the amendments, or where applicable, any determination that the notification is not required after a reasonable investigation of the incident. Records may also include written determinations from the relevant Attorney General, as we talked about earlier, related to a delay in notice, and they could also include written records for any notice transmitted following the determination. And there are also record-keeping obligations when a registrant service provider provides customer breach notifications on their behalf. So registrants must preserve a copy of any notice transmitted by the service provider to any customer on the registrant's behalf following the registrant's determination regarding whether notification is required. And registrants will also need to maintain their written policies and procedures associated with the service provider notification requirements of the amendment and related records of written agreements between the registrant and the service provider. So as stated earlier, updates to Regulation SP require registrants to oversee, monitor, and conduct due diligence on service providers. Registrants will want to maintain their written policies and procedures that describe these efforts. And registrants will also want to ensure that they're maintaining copies of their policies and procedures for ensuring that service providers notify the registrant when incidents occur at the service provider. And then we should talk about retention periods. So registrants should definitely be mindful of retention periods for the records that we just talked about. So for our registered investment advisors, you must maintain all records for 5 years, the first 2 in an easily accessible place. Broker-dealers and transfer agents, you must maintain all records for 3 years in an easily accessible place. And then we've also got funding portals, which must, of course, comply with the requirements of Regulation SP pursuant to Regulation crowdfunding, but your requirements are a little different. So funding portals are required to maintain all records required to demonstrate compliance with Regulation SP for 5 years, the first 2 in an easily accessible place. And then we've got investment companies, which have different requirements from all that we previously mentioned. And you must maintain copies of your policies and procedures in effect, or that at any time in the past 6 years were in effect in an easily accessible place. Other records must be maintained for 6 years, the first 2 in an easily accessible place.
Great, thanks for that overview, Michael. So Steve, we'll turn to you next. So in general, what are some practices registrants can consider in preparation for the compliance date?
Sure, Matt. So in addition to reviewing and understanding the amendments to Regulation SP, registrants can consider engaging with stakeholders within their organization and also at service providers to draw on an expertise that exists there in functional areas and in compliance, information technology, or in legal areas. They can also consider reviewing policies and procedures for both at the registrant and at service providers to update those where necessary to ensure they're in compliance with the new amendments. Registrants can consider testing your processes to ensure they are operating effectively and as intended. Registrants can also consider educating and training your officers and staff so all understand any new or changing responsibilities. And finally, registrants can consider ensuring that service providers are aware of the regulatory changes and are able to comply with any changes based on the registrant's expectations.
Thanks, Steve. And another question for you. What are some activities that the division is considering in preparation for the updates to Reg SP?
Sure. So the division's fiscal year 2025 examinations priorities document states that in preparation for the compliance date of the Commission's amendments to Regulation SP, the division will engage with firms during examinations about their progress in preparing to establish incident response programs that are reasonably designed to detect, respond to, and recover from unauthorized access to or use of customer information. The division will continue to prioritize examinations that assess registrant practices to ensure the safeguarding of client records and information. The division will continue to focus on third-party products and services, in particular the information security and resiliency risks associated with the use of third-party products and services. During exams, staff may also ask questions about the registrant's preparedness for the Regulation SP updates. So staff may ask your offices and employees to describe efforts being made in reference to the amendments, and staff may solicit feedback related to any implementation challenges that exist. The division will continue to engage with registrants through events like this one, and the division has issued several risk alerts related to Regulation SP in the past, and on related topics, and the division will continue to evaluate the merits of future risk alerts on these topics.
Great, thanks, Steve. And on the topic of risk alerts, can you discuss some of those publications that Exams has released in the past and how they could be helpful to our listeners?
Yes, sure, Matt. So all of the risk alerts I'll be discussing are available on the SEC's website, sec.gov. The division released an April 2019 risk alert that was focused specifically on Regulation SP issues that were identified during examinations of investment advisors and broker-dealers. That risk alert discusses observations on personal devices used by registrant staff, training of registrant staff, monitoring of compliance with registrant policies and procedures, protection of information sent outside of registrants' networks, inventorying personally identifiable information, and access rights and controls issues. And I would just note that a caveat here that the Commission's 2024 adopting release states that certain previous staff statements may be superseded to the extent they are inconsistent with the regulation SP amendments, and the release states that this may include this April 2019 risk alert. A more recent April 2023 risk alert highlighted observations related to the protection of customer records and information at registrants' branch offices. And that discusses observations on vendor management, data classification, technology risk management like patching, email configurations, and access management. The division has also released several risk alerts that highlight various cybersecurity threats and observations on topics such as secure cloud storage, ransomware, credential stuffing, and electronic investment advice. And finally, in January 2020, exams released the Cybersecurity and Resiliency Observations Report. The report highlights practices firms could consider based on observations from examinations on topics including mobile security and data loss prevention. And the report encourages market participants to review practices, policies, and procedures on cybersecurity and operational resiliency. And Matt, these reports really show that these topics have been a focus area for the division for many years.
Well, thank you, Steve. And with that, that concludes our panel. So thank you again to our panelists for sharing their perspectives today, and thank you to those who are listening. We'll now take a short break to regroup for Q&A session, so please stand by, and we'll be back shortly.
Well, hello again. I would like to welcome each of our panelists back to answer some of the questions we received. So I will start with Sal because you did mention NIST a little earlier. So one of the questions is, are there specific frameworks, for example, NIST or ISO, the SEC recommends or expects firms to follow?
Sure. So I think foundationally we need to say that there's no requirement to explicitly follow any of the industry standards. That being said, as I mentioned during one of my responses, we do leverage industry standards to facilitate much of our review. Again, not to say it's prescriptive, but if you look at many of the NIST guidelines, they talk, I don't want to say specifically, but they give you a structure to assess your organization and to determine what components of your organization you can apply the industry standard to. Obviously, we've seen many organizations leverage NIST, leverage ISO, leverage COBIT, and other industry standards depending on the technology, OWASP for another. So from that perspective, there's plenty of industry standards. I would leverage them as a guide, and I think most registrants do. But again, there's nothing prescriptive that requires you to be to the T on those industry standards. So.
All right, well, thank you. And we've gotten several questions about the rules' applicability to private funds and their advisors. So for example, some questions that came in were, does Reg SP apply to the underlying limited partners of a private fund? Are exempt reporting advisors or private fund advisors subject to any parts of SP? How impact of amendments to investment advisors that only have institutional clients, and the rules of application to private fund investors could be characterized as ambiguous as they're not customers. Could you clarify the rules applicability to natural person investors in private funds? So I think we could sum all of this up to basically ask whether or not you could provide any guidance about how advisors to private funds should think about whether they have responsibilities under these amendments.
Yeah, absolutely. Happy to take those on. I think those are great questions. I think here it's useful to go back to the framework that the Commission laid out in the rules. As the Commission stated in the adopting release, private fund that is a 3C1 or 3C7 fund is not itself a covered institution that's subject to Reg SP. But an investment advisor that's registered with the Commission is a covered institution. That includes a registered investment advisor to a private fund. And so they would be subject to Reg SP and thus required to safeguard any customer information they hold. And as we discussed earlier, safeguarding requirements aren't limited only to a covered institution's own customers. Under the amendments, customer information is defined to include non-public personal information the registered investment advisor receives from other financial institutions about their customers, regardless of whether the investment advisor itself has a customer relationship with that individual. So, a key question for these advisors to ask is whether they have been provided customer information, as that term is defined in the rules, by a financial institution. If so, then the registered investment advisor has safeguarding responsibilities under SP. So that's the basic framework for analyzing these questions. That said, if advisors still have questions about how to apply this framework to their specific situation, I think the staff is more than happy to take those questions back and consider if there's more guidance we could provide in this area.
Thanks, Mike. And the next question is there flexibility surrounding the customer notification requirement if the firm is still investigating the scope of a breach? So what advice do you have for firms navigating the situation where 30 days is almost up and we still don't know what information was specifically compromised?
So I can take that question. I think Mike did a really good job of discussing that in our first panel, but it's important enough that it's worth re-emphasizing. First off, there's a very limited basis for delaying notification. A potential delay in the timing standard is restricted only to the instances where U.S. AG determines the required notice would pose a substantial risk to national security or public safety. And even then, the permissible maximum delay is 120 days stretched over 3 incremental delays. However, I think it's useful to take a step back and look at the rule text to provide a little further context on the timing requirements themselves. The rule text requires institutions first assess the nature and scope of any incident involving unauthorized access to or use of customer information. Second, take appropriate steps to contain and control the incident. And then third, notify each affected individual whose sensitive customer information was or is reasonably likely to have been accessed or used without authorization. And here's the key word: unless the covered institution determines after a reasonable investigation that the sensitive customer information has not been and is not reasonably likely to be used in a manner that would result in substantial harm or inconvenience. So as you take a look at this rule text, there isn't a requirement in the rule that covered institutions actually reach a definitive conclusion on this within 30 days. Instead, the rule text creates a rebuttable presumption that notification will be required, with the presumption rebutted when the required investigation leads the covered institution to determine notification is not required under the rule. So where the 30-day clock is winding to a close and the covered institution hasn't rebutted the presumption, customer notification would be required.
Great, thank you, Emily. Question for the exam team. Is there an estimated schedule for conducting examinations under Regulation SP?
Yeah, I'll take that, Alexis. I think if we go back to, again, one of my earlier topics, there's not a specific schedule under Regulation SP and under the new updates. Rather, we're going to leverage our risk profiles and our exam planning function to determine what registrants would meet the requirements for us to perform a review on the following fiscal year. So that being said, we hope that all the registrants are going to be in compliance as of the required date, but that's not to say you're going to receive an examination immediately. However, that's also not to preclude that you would be examined under these regulations in the next year. So short answer is we can't really be prescriptive on when we would be there, what we would do, but there's no specific schedule based on the updates.
Thank you, Sal. And I think we have time for one final question. We received a number of questions asking for elaboration on whether certain entities or persons or service providers under the rule, and as to the scope of the 72-hour notice requirement. Could you elaborate on those a bit?
Sure, thanks, Alexis. So the service provider provisions apply in full to any person that fits the definition under the rule. So that would include any person or entity that receives, maintains, processes, or otherwise is permitted access to customer information through its provision of services directly to a covered institution. So there are no exclusions built into the rule for certain types of entities. Anyone who fits that definition is treated as a service provider under the rule. And relatedly, as we mentioned in the release, institutions should be cognizant of the fact that an entity can be operating simultaneously as both a covered institution in one context of their business operations and a service provider in another one. So firms should thus be very mindful of the need to comply with all aspects of Regulation SP that are applicable to your specific business operations. Additionally, we wanted to provide a little deeper context on what the 72-hour notification provision pertains to. Under the rule, as I mentioned before, covered institutions' instant response program needs to include P&Ps that are reasonably designed to ensure that service providers protect against unauthorized access to or use of customer information, but then also provide that notification to the covered institution as soon as possible, but no later than 72 hours after becoming aware of a breach resulting in unauthorized access to a customer information system maintained by the service provider. So if you think about that, that differs from the covered institution's customer notification requirement, where you're digging into whether affected individuals' sensitive customer information has not been or is not reasonably likely to be used in a manner that would result in substantial harm or inconvenience. In contrast, this notification is to be made by the service provider for a much wider net of incidents and requires less investigation on their part. For example, if a service provider is aware that one of its servers containing customer information has been accessed in an unauthorized manner, it doesn't need to first determine whether, precisely what files were accessed or whether certain customer information was or was not removed from the server. Instead, notification of the covered institution is required at that point in order to initiate those the incident response programs that Mike and Emily have discussed here a few times. So the obligation is a little different, and it really reduces what I think is necessary in those contexts.
Well, thank you, James, and thank you all for joining us this afternoon. I hope you all found the discussion informative, and we welcome your feedback on this event as well as any suggestions you have for future compliance events. Our next event will also cover compliance with Regulation SP, and it's slated for the fall and will be geared specifically to transfer agents. So thank you again for joining us. Have a good afternoon.